We're going to begin the hour, though, in the case that is actually dark this week, the Karen Reed case, the killer or cover-up trial. While they're on a pause, that gives us an opportunity to explore all the different theories about how John O'Keefe could have died. We know that the Boston cop was found unresponsive, cold, bloodied during a snowstorm after midnight on January 29, 2022. And according to testimony, there were at least 3 possible times that the victim, John O'Keefe, could have made contact with a snowplow during that snowstorm. An old plow, nicknamed Frankenstein, drove past the house, the Albert house, at 2:30 a.m. Plus, you have Brian Higgins. Remember, he was at the house. He drove his Jeep there for the after party at the Albert house, and it had a snowplow on the front of it.
Brian Loughran told Paul Mikowski that he was driving a big snowplow in Canton that night. You'll learn that the nickname for it at the DPW was Frankenstein because it had a lot of spare parts in it. It had been around forever. Brian Loughran told Paul Mikowski that when he plows the streets of Canton in Frankenstein, he's very careful. He makes sure to check not only the roads in front of him, but also the yards to the side of his plow. He makes sure not to hit a fire hydrant or a tree or an animal, or heaven forbid, a person lying in the snow.
So when you get to your Jeep, can you describe to the jury sort of how it was that you pulled away, or what, if anything, you recall about that process?
So I got in the Jeep, started it up, may have looked at my phone, put it in drive and started to pull away, and then I'm like, put the plow up. So I reached, I moved a couple of feet. I heard it grinding on the ground. Reached for the device called a fish stick, picked it up, lifted the plow, and then drove away.
All right, so that's Brian Higgins there at the end. We watched him on the stand last week, and let's face it, he had a plow with him. He even says, I left the house, and he leaves right around the time that John O'Keefe is there. And he says, I didn't see him. I don't know why, I just didn't see him. Well, if he didn't see him, and he even says, maybe I looked at my phone a little bit, and he starts his car and the plow's down, could he have hit him? Is it possible? Could Frankenstein, the city plow, have hit him? Is that possible? Let's talk about it with criminal defense attorney and former prosecutor Michael J. Brown, and trial attorney and Professor Dante Mills. Good morning to both of you. Michael, you're no stranger to high-profile cases, and this is a doozy here. And New England is fixated on it. The rest of the country is as well. Every little nuance, every little detail, everybody, because there's a lot of what-ifs, right? How could this have happened? And what's your theory on Karen Reed? What's your take on a possible snowplow theory? Because those injuries to John O'Keefe, they just don't seem to have come from what the prosecution says, and that is that Karen Reed hit him with the SUV. Your thoughts?
Yeah, Ted, good morning, Dante. Their defense is doing a great job in that they're posing all these alternative theories to how it actually went down. And Higgins is a great guy to pick on, and he has the snowplow. He's a guy who apparently was attempting to become romantically involved with Karen Reed. And he's friends with the homeowners. So he's a great suspect, and he's a guy, like I said, with the plow, and he got rid of his phone when they wanted his phone. So he's somebody they've been zeroing in on, along with other people. And again, the defense is trying to create reasonable doubt, and I think they're doing a great job, and they are pointing out the inconsistencies in the prosecution's case.
Let's take a look at the Higgins timeline here. According to him, when he was there at the Albert house, he left around sometime after midnight, around there. He arrives, first of all, for the after party. Then around 12:30, between 12:30 and 1, he leaves. Now, that's right around the time that Karen Reed supposedly shows up to drop off John O'Keefe. He then takes this Jeep with the plow to the police station rather than going home. He initially said he left the party because they didn't have bourbon or whiskey. So now he goes to the police station. He swaps out his vehicle. So he leaves the plow there and takes another home and leaves another vehicle home, leaves there between 1 and 1:30, and he gets home around 2. At 7 a.m., he returns to the Albert residence. Dante, is it possible and I'm not saying he did it intentionally, is it possible that Brian Higgins may have clipped John O'Keefe laying there in the snow? That's how he gets those injuries on the arm, with his plow.
Absolutely. And we have to remember, and I talked about this before, Julie and I talk about this a lot. I think they overcharged in this case. They charged with murder too, which has a level of intent, and said Karen Reed intended to kill him. Even if she did hit him, and then someone comes along and strikes him with the plow and that kills him, that removes Karen Reed from that level 2 murder. It seems as if anything, she also clipped him maybe by accident and then left him, but showing intent to kill him, I think, is a problem for the prosecution. And when the defense has these other alternatives as to how he actually died or what may have been a strike or a blow that killed him, including these plows, it makes this case even tougher. So I think the defense is doing a great job. I mean, from the beginning, they've been controlling the narrative, putting up alternative theories. And during the trial, these other theories are actually starting to make a little bit of sense. And all they need is one juror to say, well, I'm not convinced beyond a reasonable doubt that Karen Reed killed him intentionally. And I think that that's an option here, because I'm not hearing anything that says that she did.
Michael, the defense actually, they're all in on this massive cover-up where John O'Keefe's in the house, they beat him up in the basement, the dog attacks him, then they drag him out into the outside. Would they be better served to have all the options open? Because the plow thing, that's kind of hard. We're just spitballing here, trying to figure it out, because nothing really makes sense. Would they be better off throwing all the different options out rather than making jurors come to the conclusion that there's a massive cover-up with so many people involved?
Yeah, Ted, I think I understand what you're saying, but I think when you listen to the closing statement, you're going to find that what they're going to do is pose all the different alternatives to the folks in the jury. I agree that they are focusing and somewhat harping on the conspiracy aspect, but they will. I'm certain that they're going to put out to the jury when they close and give their summation many different alternatives. And I think the conspiracy part of it is to really discredit many of the witnesses and then give all these different possibilities. So I think what they're doing is exactly what somebody like Dante and myself would probably go forward with.
Lots of people are raising eyebrows in this case. Also Karen Reed, though, because when Jen McCabe gets on the witness stand, she testifies that, and I believed her, that she was truthful in this part, where she says Karen Reed first says, I left John at the waterfall, and it's McCabe that says, no, Karen, I saw you dropping him off. She seems to be distancing herself from even dropping him off at the McCabe house, or the Albert house. Take a listen to Jen McCabe on the stand talking about Karen Reed, basically saying, I dropped him at the waterfall, until she's caught on it.
I say, Karen, we saw you outside of my sister's.
And what was her response to that?
She told me that she didn't remember going there. And then she started yelling, Jen, Jen. And then she was saying, did I hit him? Could I have hit him? And then she proceeded to say that she had a cracked taillight.
Dante, what do you think happened?
I think she was drunk. I think it was pretty clear from the testimony of the people at the bar, everybody that encountered John and Karen on that day or that night, that she was drunk. And maybe she did forget exactly everything that happened. And that's, again, why I think this case was overcharged. Did she strike him with her vehicle? Maybe. But proving that she intended to kill him or she did it for the purpose of killing him, that's a whole nother step. And when you have that kind of a situation where they're out at a bar, she clearly was intoxicated by all accounts and all testimony in this case. So there's going to be some differing stories. And then you have these periods where nobody knows what happened. Nobody truly knows his time of death. There's video footage that there's a gap of some hours there. from down the street. There's a lot of things here that the defense can point to that are holes in this case, but clearly Karen Reed was intoxicated that night. And I'm not surprised that she doesn't remember every single detail based on how intoxicated she was from all of the reports and testimony from everybody that encountered her that night.
Okay, Michael, hold that thought. I see you nodding your head. We're going to get a slip in a break here, but we'll continue our conversation on what happened in the Karen Reed case. Deleted calls, butt dials, tossed phones. A lot of questions here. How is it that so many witnesses in this case had trouble with their phone on, of all nights, the one that John O'Keefe died? Then later, convicted killer Scott Peterson gets some bad news out in San Mateo, California, as a judge says, no, you don't get to just test everything over again. We'll break down the judge's ruling and why the state says, hey, he shouldn't be able to test this. It's already been litigated. Stay with us.
Is that correct, Mr. Peterson? You're pleading not guilty to the 2 charges of murder plus the special, denying the special allegations?
Absolutely. That's correct, Your Honor. I'm innocent.
We are underway in the trial of doomsday prophet Chad Daybell.
Prosecutors say they will seek the death penalty against him.
Investigators have recovered human remains at Chad Daybell's residence.
There's no way, Morgan. I can never come up with this.
His wife, Lori Vallow Daybell, has already been convicted.
Now, will her husband end up with the same fate?
It's just so hard to know where the truth ends.
It's the doomsday prophet, Chad Daybell, on trial.
All right, time for trending and true crime. I still can't get over every time I see the free Karen Reed stuff that this person who's alleged to have killed a cop is a hero in this area of the country, and it's because of the distrust that so many people apparently have in this area. They believe that there could be a major cover-up, and one of the most talked about parts of the trial so far is how many witnesses either deleted some calls, threw away their phones, or they had some strange butt dial at the wee hours of the morning that they don't remember. Brian Albert, Jen McKay, Brian Higgs all testified that they did something. They got rid of their phones or some possible evidence following John O'Keefe's death.
No, the phone wasn't destroyed. I upgraded the phone.
The data was destroyed, sir. Correct?
I did not destroy any data on any phone.
Did you make any phone calls after you went to bed between the hours of 1:45 a.m. and 6:30 a.m.?
Yes.
Who did you call?
I inadvertently called Brian Higgins. Well, it's kind of like a butt dial.
Your cell phone extraction, which is the handshake for John O'Keefe's phone, and all your calls are missing, right?
Objection.
A lot of calls are missing. I'm not really even sure what's there because the numbers are it's all redacted.
And then you put both the destroyed SIM card and the phone itself, which were in a trash bag, into a dumpster on that military base, did you not?
I believe that's what I did, yes.
All right, let's talk about it with our guest, criminal defense attorney and former prosecutor Michael J. Brown, trial attorney and Professor Dante Mills, and here in studio, criminal defense attorney Eric Johnson II. All right, let's break down this cell phone thing. Eric, to you first. Especially guys in law enforcement, they get rid of their phones the day before they received a letter saying, preserve your phones, guys, because we've got a death investigation going on. So they get a little, one would assume, a heads up, and lo and behold, these guys ditch their phones. What's your take on that?
Well, that is something that the defense attorneys definitely want to harp on. The fact that these individuals may have gotten a heads up and received information that they should do something with their phones prior to receiving a spoliation notice could be something that the defense could harp on to show that these individuals may know more than what they're leading on to.
Higgins and Albert get rid of their phones, Michael J. Brown, but Does that mean they killed John O'Keefe, or are they into something else that they just didn't want to come out publicly? And it could be anything.
Yeah, Ted, obviously it doesn't necessarily mean they're the culprits, but it's a horrible look for the jury. Higgins is an ATF agent, federal agent, and he talks about throwing a phone into some type of dumpster. And then he also talks about the fact that he never transferred his old information from his phone onto the new one. Realistically, and from a reasonable standard, when you're looking at 12 people on a jury, everybody transfers their text and their phone messages and their pictures. It's just not believable. And what it does is it detracts from their credibility. It's an issue.
Dante, how do you think, to that point, because if you get a new phone, we've all gone through it, either by choice or because you dumped it in the lake or whatever, it's a nightmare to recreate, right, what you had on the other device. It doesn't make sense, does it? And what do you think jurors are taking away from that?
It doesn't. And as if I'm the defense attorney in this case, I'm reminding the jury that we live off of our phones, right? Our life is on our phone. So if you get a new phone and decide not to transfer your life over, no pictures, no contacts, you have the witness saying, well, I don't know who I called because it's all mumbo jumbo. There's no names associated with the numbers. Nobody wants to live that way. So that was a choice. And I'm asking the jury, why did they make that choice? And to me, that's reasonable doubt. How can you assuredly say that any investigation was pure when you have these things happening around it that could raise suspicion? And again, there's a steep hurdle here to hold someone responsible for murder. And that's what she's charged with. When you have all of these things happening, there was a nephew who was at the house that had his hand bruised. He had bruising on his hand in a picture, and he said, oh, I slipped leaving out of the driveway that night. It's just too many weird things happening that may not mean that they actually, was involved in the murder, but it raises too many questions, I think, for the jury to be clear of mind and for this case to be proven beyond a reasonable doubt.
That nephew, Colin Albert, also a question about he's got some missing text messages. Take a listen.
And there were at least 8 texts between the two of you, if you just count them up real quick, just about getting picked up.
Yeah.
But if you scroll down a little bit, after the end of that text string, that ends at 12:10 a.m. and it says okay. Do you see the next date?
Yes.
What date is that?
February 20th.
That's nearly a month later.
All right, so again, this is the defense has so many of these other characters, and they become characters in this saga. Eric, there's a lot for jurors to digest, and so much of this trial has been about other people, not Karen Reed.
Well, that is true. One thing that the defense can harp on and try to point out is the fact that all of these different things that have been taken off the cell phones, some of this data may be able to be retrieved from the cloud, depending on how much information may be stored in the cloud. So the fact of them destroying the SIM cards may not necessarily have been giving up all of the evidence. So that's something that the defense will want to look into to see if they are able to ascertain the information from the cloud to see who they were speaking to, what some of these conversations may have been about, or if anything that may be able to exonerate their client.
And they have, and that's where they're getting the blueprints for some of the missing things, but they're not getting the detail that one pessimist would argue these cops knew was going to be destroyed with those cards. Michael J. Brown, if you're the Commonwealth, are you worried at this point in the trial?
I am. The defense attorneys have done a great job. They have created so many different possibilities other than the theory of the prosecution. And the witnesses, they've done a great job, the defense has, in terms of attacking the credibility and perpetuating this conspiracy theory. And it really, really affected the credibility of many, if not all, of the witnesses. So, yes, I am worried if I am the prosecution. And along Dante's point, they have to prove intentional, and that's a very big hurdle to overcome.
And Dante, overcharge it can be a burden for the state, can it not? Because if you go in guns blazing, yes, at the end of the day, you might want the lesser included to be a victory, but it can also really turn a juror or jury off if you don't see any there.
Absolutely, because what happens when you charge someone in that opening statement, as for the prosecution, they have to come in with some surety. So they have to make some promises to the jury, promising them that they're going to deliver on these charges, that they're going to provide evidence and proof that backs these charges up. So yes, sometimes you can have the lower included charges that can be deemed a victory, but when you go in making promises to a jury and then you don't keep those promises, all your credibility is shot. So a lot of times, if you don't prove that top charge, then the jury says no on all of the other ones because they feel like you promised them something and you didn't deliver. And I think that's what's happening here. They could have said Karen Reed hit him by accident and fled the scene, right? That would have been a charge that to me made sense in this case, that they could have proved that he used a tail light and the fact that she left. But they went for intentional murder, and I think that they're kind of jamming themselves up right now.
Yeah, there could have been a plea with the other scenario if it would have gone that way, but it didn't. And here we are. Now you've got World War III up there in Massachusetts. Dante, thank you. Enjoy the rest of your day. Appreciate your valuable time.